AHLA is pleased to present this special series highlighting the top 10 health law issues of 2022, where we bring together thought leaders from across the health law field to discuss the major trends and developments of the year. Support for AHLA in this series is provided by PYA, which helps clients find value in the complex challenges related to mergers and acquisitions, clinical integrations, regulatory compliance, business valuations and fair market value assessments, and tax and assurance. For more information, visit pyapc.com.
Welcome and thank you for attending today's AHLA podcast. My name is Michael Ramey. I am a principal with PYA, leading our transaction advisory services. I'm joined today by Liesl Dunlop, who is a partner with Axon based in New York City. Liesl has more than 25 years of experience in antitrust and competitive issues, guiding clients through antitrust-related aspects of mergers and acquisitions, joint ventures, and other combinations. She also represents clients in antitrust agency investigations, including a myriad of major corporations and complex litigations. Liesl, thanks for joining us today.
Thanks, Mike. Glad to be here.
Great. Well, our discussion today is based upon a recent article that you wrote for AHLA titled Provider M&A Faces New Antitrust Headwinds. And within that, you noted, amongst other things, the shifting dynamics in federal antitrust enforcement. So I know we've got a lot of individuals who are listening that may have a varied level of understanding of just the antitrust environment. So if you could maybe start by level setting just a little bit and advise on kind of what some of those key pillars on which the FTC has historically based their enforcement actions and how those may be changing under new leadership and political direction.
Sure. So what we're talking about here is review of transactions, be they hospital mergers, health insurer mergers, provider practice mergers, or vertical mergers that involve various of those constituencies that are going to be reviewed under Section 7 of the Clayton Act, which is the provision that prohibits anti-competitive mergers. Those kinds of transactions are reviewed by the FTC or the Department of Justice Antitrust Division. For the most part today, we'll be talking about the FTC. That's where the hospital and provider transactions generally fall to be reviewed. And so traditionally, these deals have been reviewed under the horizontal merger guidelines. The most recent iteration of that was in 2010. And from about 2004, I think you can kind of view the historic or the modern approach to the review of these transactions. And since then, the FTC has brought a lot of merger challenges, many in court, and it has been pretty successful over that period of time. Basically, the agencies or the FTC will look at inpatient general acute care services when they're talking about hospitals. That's a cluster market of a range of services that most general acute care hospitals offer. In some cases, you will kind of drill down into particular specialties or particular types of services where there might be concerns about a narrower scope of services. And then the agency will also look at the geographic market that's in issue. And there's often a lot of dispute about what the scope of the geographic market is. The FTC focuses on it from a payer perspective, not so much patient flows, although where the patients go is certainly relevant to the network that a payer needs to develop. And then the FTC, once it's defined its market, will look at what the market shares in that market are, and applying the Hirschman-Herfindahl Index will come up with a series of measures of concentration and what the transaction actually does to concentration to determine whether or not it's presumptively harmful to competition. A case in which there is that presumption, there will have to be quite a lot of strong arguments in defense before the FTC would be convinced that there wouldn't be a problem. And when there is a problem, they will indicate to the parties that they're going to challenge, at which point the parties could just stop the transaction, abandon the transaction, or the FTC will actually bring a challenge in court. And as I mentioned, they've done that quite significantly over the years. And when the FTC is arguing about competitive effects and considering competitive effects throughout this analysis, the focus has typically been on price effects. So the effects on payers in terms of the prices that they're paying for these services, with some discussion about quality. Usually in response, the parties will bring forward things like improved quality and bringing common electronic medical records and those type of factors. But fundamentally, the concern will be about price impacts. So that's the existing framework. In terms of how it might change going forward, I don't think in the near term that basic framework is going to change so substantially. We're going to continue to be concerned about concentration. And certainly in the statements coming out of the Biden administration, the directive to the FTC has been, challenge mergers that lead to high concentration. And if anything, the concerns that we're hearing is that in the past, too many concentrative transactions have been allowed to go through. Certainly, we've seen a lot of challenges, but there are probably a body of transactions that don't hit the presumptions that are in this kind of mid-range, but are still concentrating markets. And so you may see more enforcement at the lower ends of those concentration levels. Not just the 3-2s or merger to monopoly type situations. And then the other major change that I think we're already seeing is on the scope of the investigation, the range of competitive harms, the types of theories that the agency might be pursuing. And we've already seen the FTC withdraw its vertical merger guidelines, and talking about, as well with the DOJ, reviewing and reassessing the horizontal merger guidelines with a view to potentially expanding the scope of investigations that might raise concerns. There's been a discussion by the FTC chair in particular about a broader and more holistic approach to antitrust enforcement, not just in the mergers area, but generally across their work in investigating misuse of market power or anti-competitive agreements or those types of actions. And so you'll get more consideration of factors outside necessarily these strict price effects.
That's interesting. You've mentioned considerations outside the price effects, and and some of the other more commonplace analyses. Would you maybe expand just a little bit upon kind of what are those factors that are outside the typical guidelines that everyone is used to referencing in the past that are now being considered?
So I think this is a movement that we've been seeing for the last maybe 5 years or so, maybe longer actually, that there has been a big critique of the current paradigm of antitrust enforcement, which focuses on impact on consumer welfare, this economic concept of consumer welfare. And so over the last 5 to 10 years, you've had a lot of commentators criticizing the agency's reliance on looking at price effects and defining markets and in strictly economic terms, and not taking into account broader concerns with maybe social concerns, impacts on workers, impacts on small business, and things that might not normally have been considered at the core of antitrust review. And the way that this is playing out in particular right now is a huge amount of focus on labor markets. So whereas before you would have gone into the agency and really the focus was on payers and provider dynamics and what kind of a network a payer needed, what the payers actually said about the transaction, What we're facing in addition to that is a lot of questions about workers, nurses, doctors, nurse practitioners, other kind of home and facilities-based health workers. What is going to happen to those workers in the transaction? And that opens up a whole lot of investigation of what is the current landscape for healthcare workers in this particular region. What are the alternative sources of employment for these people? What are barriers to them moving around in terms of certifications? Maybe we're dealing with a cross-border area where there might be different state certifications and licensing. Is this an industry and an area of the country where non-compete provisions might prevent people, or other employment contract restrictions might prevent people from freely moving around? And that does raise a lot of questions about when you're doing a transaction. Occasionally redundancies, impacts on your bottom line in terms of your labor cost, are going to be one of the factors that lead to improved efficiencies of the combined organization. So you've got this kind of push-pull of concern about impact on workers on the one hand, and yet pro-competitive benefits of the transaction in terms of lowering cost on the other. I think right now the healthcare labor market is so tight. It's going to be interesting to see if it is possible to prove an adverse impact on some of these categories of healthcare workers. But that is one area that we're very interested in seeing how it pans out. The DOJ and I think John Cantor at a recent program that the agencies ran on labour market impacts in transactions generally, not just healthcare, did say that labour markets are like any other markets. The emerging parties might be on the other side of the market from what we're used to, but the same competition analysis considerations come into play, and so we can expect to see over the next months probably some transactions being challenged on that basis, maybe not solely on that basis, but I think we can expect to start seeing those kind of claims coming through in the challenges. A couple of other areas that that I think that's a major thing I'm seeing, but quality's always been a really important aspect of efficiencies claims, benefits, impacts on quality. I think we're going to see a lot more focus on that, and there could be some new kind of ideas that are a little outside the realm of economic impacts. So social impacts, impacts on particular socioeconomically disadvantaged populations, things like that may get a little bit more play.
Lisa, that sounds like the defense is going to be a lot more subjective than objective on these whenever you're taking it out of economic and market share parameters into questions of impacts on the broader labor market, the quality of care that's resulting from the combination. Do you agree with that?
I do, and at the same time, that's a big challenge for both sides because qualitative impacts are very, very hard to assess, particularly predictively, and that's what you're doing when you're looking at a transaction that is about to happen. Hopefully, that you're crystal ball gazing a little bit. You're postulating that we can deliver on certain of those kind of more qualitative, squishy kind of areas, and it's the proof that you're going to have to bring to the table is going to be important. And how do you develop that proof? How do you actually set out a plan and criteria and things in a way that is going to be persuasive and actionable?
Great. Switching gears just a little bit, going back to some of your prior comments, you mentioned the increased enforcement by the FTC, particularly on hospital transactions. Now, we've witnessed in prior administrations that there has been a history of, I'll say, differing opinions between maybe the federal and the state, at the federal and the state level, on whether or not transactions should move forward. And we've even seen transactions consummated under things like Certificate of Public Advantage or COPAs in various different states. Given this recent pronouncement, how do you think this increased federal enforcement effort is going to impact those dynamics between the FTC and state attorney generals or whoever has the regulatory oversight for these transactions at the state level?
Now, that's an interesting question. To what extent that dynamic is going to change. I think, those examples that you mentioned on the COPAs and separate state settlements, I think that's reflective of the really broader role of state government in healthcare delivery. The FTC is really only looking at these transactions from a competition standpoint and, price competition and quality of competition to a lesser extent. The state AG's offices and other state departments are looking at a much broader range of considerations. So they'll have their people who are focused on competition policy, who are looking at the same things that the FTC is looking at, and often, in close collaboration with the FTC and working in step with them. But you'll also have, various other constituencies there. You'll have charities bureaus. You'll have, when you're dealing with payer mergers, you'll have departments of insurance commissioners. You'll have departments of health, of course. And so, the state government has a broader range of concerns than just the competitive aspect of the transaction as it applies to commercial payers. They're going to be interested in the impact on the public pay side of the equation. They're going to be concerned about sustainability, about continuing services to rural areas or socioeconomically disadvantaged groups who may be reliant on a particular facility. And also more generally in improving various criteria of public health. I think in the Ballard transaction, Wilmot Mountain States, that was a big concern, that the various kind of indicia of public health in the region that system served were, critically low in some instances. And so a major reason for permitting that transaction to proceed under a COPA, a Certificate of Public Advantage, was to allow new programs and coordinated programs to improve health in that region. And those are the kinds of considerations you're seeing given play in, for example, the Pennsylvania AG's settlement with Jefferson Einstein recently. Initially, the FTC and the Pennsylvania AG's office brought a challenge to the transaction. That was one of the rare instances that the FTC was not successful, and they were planning to appeal. But in the meantime, the state attorney general did a settlement with the parties and expressly to allow Northern Philadelphia healthcare market to be improved by that transaction. And most of these settlements contain fairly detailed provisions around pricing, giving pricing protection, as well as detailed provisions around meeting various milestones and thresholds over time about achieving the efficiencies that are predicted and claimed will result from the merger. We saw the same thing up in Massachusetts with the Leahy. So it's a complicated dynamic. The FTC has traditionally been very hostile to those types of actions by the states. In Wilmot Mountain State, the FTC participated in the COPA process, made a lot of submissions about the adverse impact on competition and why permitting the transaction to go ahead would be a bad idea. Ultimately, they weren't successful. And, so it's hard to understand how that is going to change. Will the agency suddenly become more accepting and cognizant of the social benefits of transactions to the, and look at that instead of, or allow those considerations to counter the price effects of a transaction? I'm not sure that that's how it's going to come out.
Okay. Yeah, a lot of unknowns at this point, I'm sure. Another unknown that you mentioned in your article had to do with the notification that prior consummated transactions still may be subject to further review. Have you seen any indications thus far as to maybe what type of characteristics might invoke that type of a review, or how far back that might go for those, especially who are participating, who may be a part of a transaction that recently consummated? Any words of wisdom there as to who needs to be on the lookout?
So, the FTC has always been able to challenge a consummated merger. And, a lot of healthcare transactions actually fall below the threshold for a Hart-Scott-Rodino notification. That's the law that gives the FTC the ability to look at a transaction and stop a transaction before it's happened. So a lot of deals that don't get reported don't have that statutory bar to close, and they'll go ahead and close. And it's only after they've been consummated that the FTC will find out about it, usually because there's been some impact on the market. Prices have gone up quite dramatically, and there'll be a complaint to the FTC, and they'll start investigating. And Evanston Northwestern was an example of that. And then St. Luke's also was another example of that. And after the challenge, there's some settlement. So in St. Luke's, they were required to spin off the physician practice that had been acquired. So you've always had that. I think that the difference right now is when you did a Hart-Scott-Rodino notification and you got cleared, either in a initial 30 to 60 day period from an initial investigation, or you might have gone through a second request. You were safe. Theoretically, of course, the agency could come back to you, but usually after a Hart-Scott-Rodino process, your transaction was, you had a fair degree of confidence that your transaction was okay. And I think what we've been seeing out of the FTC, presumably due to workloads, because there have been a tremendous number of transactions filed over the last year with filing numbers far exceeding what had been going on before, is that you'd make a filing, you'd have an initial investigation, which you would normally have expected to result in no action. And at the end of the waiting period, as that waiting period is expiring, the agency doesn't issue a second request, which is where they would normally go if they had concerns, but instead sends a letter saying, we're going to keep looking at this. And if you want to close, you're allowed to close because there's no Hart-Scott-Rodino Act problem, but you do so at your own risk. And you bear the risk if we keep investigating and subsequently find that this is a bad deal. So when those letters started coming out, everyone was pretty concerned. And what does this mean? And should we really not close our deal? And it was incredibly disruptive. I think that now that we've seen a fair number of them, people are closing through them. But it does leave you with this discomfort that you could get an investigation down the line, and that your deal could be reopened. So, my concern here really, I don't think that much has changed on the smaller below the radar kind of deals. I mean, they're always going to be there, and the risks are in how the transaction actually plays out when it's closed. I think the change that we're seeing here is in the deals that are actually reported, and what might happen even after you clear HSR and close your transaction.
That's helpful, Lisa. Thank you. Lisa, one more question that I have for you, and again, going back to your article, you mentioned that not only are health systems in focus, but also physician practices, other ambulatory services. Now, when we've talked about so far, everything has been under the purview of the FTC. We're also seeing a lot of payers who are involved in acquisitions, specifically of physician practices, other ambulatory services. My understanding is that invokes then, Department of Justice. So you mentioned I'm using quotes here, whole of government competition policy as something that came out. So do you see maybe the FTC and other agencies kind of coming together to evaluate some more of these transactions that may have been bifurcated previously?
So, on the payer provider kind of merger, we've always had those, and I think a big change there is that they were reviewed under, the vertical merger guidelines were only brought in last year, but the guidelines basically reflected agency practice up to that point. And going forward, those guidelines have been rescinded. So there are questions around what are the criteria that the FTC or DOJ are using to look at vertical transactions of provider payer combination, or maybe ancillary services acquisitions that aren't strictly horizontal overlaps. And before, earlier last year, we did see the FTC announcing a retrospective review of past provider physician transactions and ancillary services transactions. So, I think that they're gearing up to do more work in that area. The whole of government approach is a little bit different, though. That was a directive that every government department look at its scope of responsibilities and see to what extent competition policy needs to be taken into account, and whether there are ways in which different government departments, not just the FTC and DOJ, can promote competition through their own policies. And I think in the healthcare area, the main institution there is going to be CMS, and are there things that CMS can do through its policies to influence competition in healthcare markets. You may see more collaboration between CMS and FTC DOJ in terms of trying to achieve more competition in the healthcare system. Particularly through Medicare, obviously, and Medicare Advantage, and the Medicaid program. So I think that could raise a number of really interesting areas for study and investigation. Don't know how it's actually going to play out in a transaction review.
Well, Lisa, really appreciate your time today. Thank you for sharing your insights, and thank you for the article. There's obviously a lot developing here, and I'm sure there's going to be continued focus over the year as the enforcement continues to evolve and we understand a little bit more. So thanks again, Liesl, and thanks for those attending.